Hi everyone. Today we're doing a segment called FAQs, answering your frequently asked questions. So here's a question we got from one of our viewers, and they asked, if I sue the driver who hit me and lose, do I have to pay his attorney's fees? Well, the answer to that is no. In New York, you would not. If you sue a driver who hit you because you feel that that driver was at fault and you suffered an injury, and then ultimately, when you go to trial, you lose the case, you basically recover nothing. The attorney who's handling your case is doing so on contingency, meaning if you win the case, the attorney would be entitled to a piece of the pie. If you won 100,000, the attorney would take 30, you would get 70. But since you got nothing and you lost the case, you get nothing. But you don't have to pay because you presented a valid claim. There was a car crash, you presented a valid claim against the defendant, and it just so happened for whatever reason, maybe it was liability, perhaps it was the jury didn't believe your damages, your case was dismissed. Some cases are lost. Statistically, I'm not sure if it's 50-50, but there's statistics on it, how many cases are lost. But you don't have to pay that defendant driver's legal fees in any way, shape, or form, because that defendant is actually represented by the insurance company, right? That defendant is paying a premium every month or every year, however they pay, to Geico, Allstate, State Farm, Liberty Mutual, whatever company, and then that insurance company is then providing that protection to their policyholder, to their insured. So what happens is when they get a lawsuit, the driver sends the lawsuit to the insurance company. The insurance company then hires an attorney to defend that defendant. And then whatever happens, if there is a judgment, they pay the judgment in accordance with the policy limits. In some states, if there's a judgment beyond the policy limits, they'll pay more because there could be bad faith. In New York, the bad faith law is not so strong. There have been some instances of bad faith, but it's much more difficult to prove. But essentially, there's not really too many scenarios where you would have to pay the legal fees, because the legal fees are between the insurance company who's paying the legal fees for the lawyer that they choose, either in-house counsel or an outside law firm, and the defendant. The defendant doesn't pay the legal fees either, right? The defendant is just paying for the premiums for their insurance. So I hope this has been helpful. So the answer is no, you would not have to pay. I mean, the only potential scenario is if you're bringing like a clearly frivolous lawsuit that has no merit, then perhaps the judge could issue some kind of sanctions, but that's not really the same as paying the legal fees of the defendant. So the answer to this question is no. Let us know what questions you have, and we'd be happy to add you to this segment called FAQs and answer your questions with a video. Have a great day, everyone, and bye-bye.